to Coming to the Table. My name is Keld, and this time I have the honor and pleasure of having a gentleman I met at a conference in Florida, and which inspired me a lot within the world of negotiation. David is an attorney based in the Bay Area here in the US, and he has some exciting thoughts about how we collaborate or how we could collaborate. And I am thrilled and honored and happy that, David, you would take up the time to participate on this show we got here. So thank you so much for being here, David. And could I ask you to do a brief introduction about yourself, your organization, and what you're doing today?
Yeah, I'd be happy to. So first of all, thank you for having me, Keld, and it's been great getting to know you, and I have found your work fascinating and am eager to learn more.
Thank you.
So I wear a couple different hats. I'm the founder of a company called Tech Contracts Academy, where we train both business people and lawyers on how to draft and negotiate information technology contracts. So cloud computing, software licensing, technology-related services. So we teach the substance of the clauses, and we also teach the knowledge that people need to do a better job negotiating them. I'm also the author of a book called the Tech Contracts Handbook, which is the same subject matter. It's published by the American Bar Association, and it also teaches the substance of information technology contracts.
Right.
And then finally, I'm the founder of a law firm called Sycamore Legal in San Francisco. We're a boutique firm doing intellectual property and technology deals. So the kind of deals I teach about are the kind of deals that I do. And then I'll just throw in real quick on the side, I also do some completely unrelated but very fun work, which is writing about history and science for kids. I write fantasy stories that teach history and science, including the Jericho River.
I would love to do something like that, David. We have to talk about that one day, how you could train me in doing exactly that. Really David, you just mentioned technology, and in technology and negotiation is something that has my interest these days, because I meet people who tell me that, they look forward to the day where artificial intelligence will do negotiation instead of humans. They claim that will give us better outcome, it will give us better result, and computers will basically be able to conduct better negotiations than you and I. Would you agree or disagree, or what's your thoughts on that?
I more or less agree with that prediction. The question is how far in the future that point is. There's a lot of debate about what artificial intelligence can do. I worked with AI companies in my work as a lawyer and a trainer. I don't see any particular limits, frankly, in what can be achieved. So the idea of eventually having two computers exchanging information in order to create a smart contract does not seem far-fetched to me. It doesn't also seem right around the corner. I don't think, the companies that I work with that I see doing artificial intelligence, none of them is anywhere near that. And I don't know that we see that kind of system in the next 10, 20 years. I mean, that takes a tremendous amount of AI sophistication. Sure. But in the end, a smart contract, it's the concept of computers exchanging information and looking for sort of that Pareto optimal solution. Computers are well suited for that kind of thing.
Right. Another question for you, David. You obviously engage with a lot of human beings, a lot of clients in negotiation, helping them improve their contracts and negotiation. And a simple question, not only directed towards your clients, but human beings in general. Are we good at it? Are we good at negotiating?
Yeah, it's a good question. And it sort of relates back to the first question about whether those computers will be better at it than we are. The way to put it is there's a lot that we can do to do negotiations effectively that I think most of us just don't think about. We go into a negotiation without thinking through techniques and strategies very much. We just sort of charge right in. And it's very tempting to do. You've got a busy schedule. So I think a lot could be done to improve what kind of negotiators we are by sitting down and breathing for 15, 20 minutes, a half an hour before a negotiation, and going through some negotiation strategies that we've found over time work for us. And I don't know that there's necessarily a list that I would consider the right set of strategies for everyone. We could be much better if more of us took the time to think it through before diving in.
Right. When you look through your experience, what is the typical fail that you would say you see some of your clients are doing, or perhaps even you have seen yourself doing throughout your experience?
Yeah, so there's a lot of ways that we typically fail, and both me and my clients are guilty. Um, I think the most obvious and frequent thing that I know you talk about in your own writing is the sort of win-lose. We've got a list of things that management wants us to get out of the negotiation, and we go after them without concern for how it impacts the other party. If we get them, we have a victory. And I think that often leads to a fail, and sometimes an invisible fail, in that you don't get the most optimal solution by really listening to what the other party wants and seeing how you can get achieve your goals without it. I think another fail is just we let the personal side get in the way. And I don't mean to suggest that the personal side doesn't belong in negotiations. It is a personal interaction. But we allow frustrations and irritation with personality quirks of the other side, or with their unwillingness to listen to reason, get us frustrated. And whether we end up making a scene or keep that frustration well hidden, that blinds us a great deal. I think those are very frequent sources of negotiation fails.
Very good input. Now, you being an attorney, David, do you see that a negotiation approach, or how we conduct negotiation, could be perceived differently from an attorney's point of view versus a more corporate, commercial orientated person? Can those two approaches clash, or are they very identical?
They definitely can clash. I think a very good attorney avoids that clash, although there are limits to how much you can do that. I mean, so one of the problems that attorneys have is that we have a responsibility for the deal, for seeing that there are not legal tricks and traps buried there, the unexpected outcomes that are inherent in the contract, for instance. And we have a level of responsibility that's somewhat different from the corporate people, from the business people. We're supposed to know when this or that clause is likely to cause trouble. And that's a good thing. There's real value that attorneys add to a deal, but it gives you a focus on trouble, and it gives you a focus on risk creating and liability creating clauses that is different from the business people. And so, you can end up with lawyers who find that the easiest, safest thing is to say no. You can't get in a lot of trouble for saying no to
I understand.
this set of terms, particularly if you don't deeply understand that. It's always to say no. And I think lawyers are more impacted by that than business people. I think one of the other differences between lawyers and business people, particularly outside counsel, is we're brought in as hired guns in most of our deals. And the relationship between the lawyers on the two sides is not necessarily important long-term. This is particularly so with outside counsel, but it can even be so with in-house counsel, who might get involved in a deal and then get uninvolved in the deal. And once it's done, it's done. That has it leads to some interesting questions, like, if somebody has to fight a battle, should it be the lawyer who fights the battle because his or her relationship with the other side isn't of long-term value? And there can be a temptation in saying, well, I'm gonna slug it out with the other party because then I leave the deal and everybody's happy. Some clients actually want you to do that, and it takes some sophisticated thinking to determine whether it's a good idea. I generally would rather not overuse that factor in the attorney relationship and have good relationships even on the temporary basis, because I think you get to better deals. But it is a tool that exists, and some business people want to use their attorneys and their attorney's short-term relationship with the other side in that way.
Right. So am I hearing you saying there's a potential risk that some lawyers could actually be more short-term orientated in a negotiation because of that?
I think that's right. I mean, I think for most of us, particularly outside counsel, but again, including in-house counsel who's just going to come in and do the deal and then may not have any contact with the other party again, it is a real short-term orientation. You might prefer as an individual not to get into difficult relationships with people. But in the end, in a month or so, you will not talk to these people again.
Right,
And so
right,
you're under less pressure to get along and more pressure to protect that other side, which is
right.
the risk aversion.
Sure.
And that, I mean, in the end, that's why it's so valuable for lawyers, everyone in the deal, but particularly lawyers, to understand the content of what you're negotiating,
Mm.
because then you have much less risk aversion. If you know what you're getting into, it's easier to just put a stop to the saying, no, 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 we won't take that risk. You can
Sure.
understand the risk.
But David, how do you do that? I mean, being a lawyer, obviously, you have to be an expert within the legal field, and that's a huge area. If you, on top of that, have to understand in detail your client's assignments and purpose and target and all that, isn't that an almost inhuman job?
It could be argued that way, and some might say, well, let's just wait till the artificial intelligence comes and takes over. Not my solution. I think we have many decades more to go of humans doing this far better than computers. It is an inhuman task to some extent, but it's doable. I mean, one thing that is particularly important is as an attorney to get a business focus, to understand the business issues at stake in the clauses that you're negotiating. So every contract has, quote, legal clauses, and business people and lawyers tend to separate very artificially, I think, business clauses versus legal clauses. The first thing I think lawyers need to do to do that inhuman task is to understand that there aren't any business or legal clauses. They're all business clauses. And that forces you to ask, what is the business issue at stake behind an indemnity clause, behind a warranty, behind a limitation of liability? And explain it to your business team in that way. I think that sort of focus on the business issues is really vital for lawyers. I also think what we call in our firm the client intake interview and meeting is really important. It's the sit down with the client to go through all of the client's goals in the deals, which will generally always be expressed to you in, quote, business terms, and to think them through, and then to ask your questions about the clauses lawyers tend to want to get in and put them in terms of business goals, so that before you go into contact with the other party, you have a very broad set of business goals for the negotiation that include the business issues behind the, quote, lawyer stuff that tends to be a source of a lot of debate.
Right. David, I think you're the first lawyer I ever heard actually saying everything is business clauses, because most attorneys I've met throughout the world is actually saying, well, we have the legal clauses and then there are the commercial clauses. What's the reason that you came to that conclusion that everything is actually a business clause?
You know, I think that in the end, it was the result of both my training and my writing my book. My book is a very user-friendly source on tech contract, and I wrote it to be useful to both lawyers and business people. So for the business people audience, I needed to, with great care, explain what the business issues are. And I found myself doing the same thing in trainings because I train contract managers and executives and other non-attorneys. And so it's forced me into a series of exercises where I explain what's at stake to you, business person. And that has led to this focus. I gradually realized that there just aren't anything but business issues. There are very complex issues that you need lawyers to help understand. But in the end, are we going to pay money to the other party? Are we going to be obligated to protect the other party? Are we going to be restrained from doing this or that type of deal?
Right.
When you boil it all down, you get to those business questions.
Right. Very interesting. Very interesting. David, another question. Do you think that the lawyer is partly responsible of coaching their clients on how to negotiate? Or are they just, as you said, a hired gun?
Yeah, it's a good question. I don't think there's a particular lawyer responsibility there, but I think that a good lawyer does. So a good lawyer, in-house or outside counsel, is a business consultant. I think lawyers should look at themselves in that way. And any lawyers listening will say, yeah, my clients ask me a ton of questions that are really management consulting questions, how to manage relationships. So I think good service involves that kind of negotiation counseling. The challenge is, of course, we're not necessarily better trained as lawyers to negotiate than our clients are. A lot of us get a negotiation workshop in law school. I had one, but it's less of a focus in the profession to teach negotiation than it is to teach the substance of what we're doing. And so we're not always in a great position. And you know, very often our clients are better negotiators than we are. I think one of the key things is to be very conscious of where the negotiation strengths and weaknesses are on the team, and defer to the client's negotiation strategy if you think the client's the one who really has a handle on it.
Sure. If you look back through your career, is there a specific negotiation that you are particularly proud of, something that you think went really, really well?
Yeah, there are a few. And you know, it's funny, the negotiations that I tend to feel best about are the really large ones, and not because it was really large, but because the scale of the negotiation led us to clear away a lot of the obstacles that usually limit negotiations. So in a you know, a very large, say, technology outsourcing deal, there's enough money on the table that you're not worried about flying lawyers across the country or across the world to meet with each other, taking time to really get the team together. And so the negotiations I'm most proud of are the ones where despite a lot being at stake and some very difficult issues, there were the resources and time available to sit down with the other party and really get to know each other and negotiate face to face.
Right.
That kind of very, you know, in a very complex and possibly tense deal, that's made a real difference. And in some of those cases, I've just, you know, I've pulled the other lawyer out of the room in a difficult situation where we're not getting anywhere and said, let's just get coffee and talk it over.
Sure.
And figured out all kinds of stuff with us both sort of pushing the other's limits and testing what can be done out of the view of clients who we don't then have to posture for. And that kind of thing has led to results that I'm really proud of.
Sure.
There's some that I'm not so proud of too. I mean, and it usually tends to be the opposite, where there isn't the time and the resources to really do that kind of thing.
Yeah. Have you experienced, David, that even in merger acquisition deals where a lot of money is on the table, that the parties don't really take the time to do what you just said?
The parties don't take the time necessarily to do that in all kinds of deals. So we actually don't do M&A deals. We just do cloud computing, software licensing. Right. Although I've been involved in plenty of M&A deals. Yeah, there's a real temptation to just charge into the negotiation with your list of stuff that you want. And so you don't take the time to get to know the other person. Right. The tool that I'm finding more and more useful to avoid that problem is the one you and I are using right now, which is video conferencing. It's not quite the same as meeting in person. I would much rather meet in person, but where that's not practical, the getting to know each other in the talk by seeing each other's face can have a really big impact.
Oh, I completely agree. World Economic Forum published last year a study that claims that negotiation skill is the fifth most important skill, regardless of what job you may be in. Now, I live and breathe negotiation, as you know, David, and I was even surprised that World Economic Forum would put it that high on the list. Have you got an opinion about that study?
I've read that too, and it does make sense to me. I think that, you know, as you pointed out in your own writings, we have both formal and informal negotiations. We are negotiating with our colleagues all the time. And so I do think so. I do see it as a constant necessity. My focus is on the formal side of negotiation, because we sit down and formally negotiate deals all the time, and I train my students to do so. And there I see how frequently it can go badly if people just had a few basic negotiation skills, and how much of an impact it has on their company and their own career. In fact, you know, it might be helpful to talk about a couple of those particular skills that I see valuable. And this is very much from the point of view of the contract drafter and negotiator. So some negotiators work at a relatively high level, and they don't have their fingers in the contract. For me and the people I work with and the people I teach, we do. And some of those skills that I think people's success would be much greater if they understood is questions like, how and when to communicate with the other party in writing through a contract draft, and how and when to do it in person.
Yeah.
It's one of the most vital things that I see causing negotiations to go wrong. It's the tendency when receiving a red line of your draft of the contract to shoot back with the revisions you're willing to accept and those you're not.
Yeah.
Which, in my view, once each side has exchanged a draft in paper, you're done doing that. You need to talk between red lines. So failure to miss that kind of pattern. Each side sends a draft and then you start talking between drafts. That kind of basic fundamental pattern is so fundamental to success, and yet so few people know it. To me, it reinforces that study from the World Economic Forum.
Right. Very interesting. Thank you for your thoughts on that. As you might know, David, one of my fields is studying of trust, or rather what I call the lack of trust between parties. And a lot of studies claims that trust has actually been dropping, especially in the Western world in the last 20 years. I call it trust currency because trust is equal to a monetary value. So if we have a high level of trust, our transaction cost will go down and profit will go up. And obviously, if we have a low level of trust, the opposite will happen. How do you see the importance of trust in your work?
Yeah, I like the idea of trust currency. It fits my work a lot. So trust is a constant issue. And again, I'm sort of sticking to what I call the formal negotiations when we're really undeniably sitting down to negotiate. Obviously, trust is probably an even larger role in informal negotiations. But in formal negotiations, I see situations, for instance, where I'm representing a particularly large, sophisticated client, and the other side is smaller. Yeah. And there's an immediate trust deficit, that there's the other side worrying that we have all these tools and tricks in our handbag they don't have. And you have immediate problems of low trust there. And bridging that gap is difficult. One way to do it, I think, is trying to speak with intense sincerity, to acknowledge weaknesses in your position openly, to mention them before the other side does. Another thing that I like to do is when I'm not falling into the emotional negotiation trap or the barreling straight through trap, but when I think of it, I like to try and express the other side's position as well as I can. Say, all right, let me understand this. Here's what I think you're after. Here's what I think. And say it in a way, express it, possibly even better than they could. Express it well without any advocacy for my position hidden in there. Those kinds of techniques help bridge that trust gap. But it can be tough, and it's particularly tough, again, between lawyers who really, everybody knows, as I said before, won't be involved in the deal afterwards. The sense that you want to get the best deal you can at their expense, and that's not always crazy, and that's a real trust challenge.
Right. Now, obviously, once again, you being a lawyer, David, do you think sometimes that lawyers feel that they have to take on a role, behave in a certain way on behalf of their clients, look like the tough guy, the combative person, the good cop, bad cop case? Is that something that could happen? That they take on a role that is not necessarily them?
Yeah, it does happen a lot, and you'll see. There's a couple of different types of roles lawyers take on. The less common one, although it makes for better television, is the pound your fist on the table role or some sort of tough guy role. Sure. And a lot of lawyers think they need to do that. The more insidious and common troubling role that I see people take on is the I know everything role. It's not that the lawyer necessarily feels he or she has to be the tough guy. It's that the lawyer feels he or she can't admit lack of knowledge. And that is more dangerous, I think. The tough guy, you can get through it. It's a little silly, I think, but you can get through it. It's where you're not able to say, I don't understand what you're talking about. I don't understand how this clause works. I'm not familiar with this area of law. If you can't do that in front of your client, you're going to have to put yourself into all kinds of difficult and uncompromising situations. Again, the safest thing to do if you don't understand is to say no compromise. That role of expert in everything that I think lawyers have to watch for. I think you just have to accept it's okay to say, I don't know. I'm going to check with partners who know this area better. I need to research this and it builds trust too to say it up front. I don't understand this issue. You explain it to me, then I'm going to go off and do some of my own research on it. And to realize that's okay. Lawyers don't have to know everything.
Right. David, if you should give one important advice on the whole world of negotiation to our viewers, what would that single advice be to them?
One thing. It's very difficult to boil down to one. I'll tell you one that I give to my students, which will instantly bore you and your audience, but is so important. It is to be a master of redlining technology. So we negotiate contracts. We need to see in a very simple way what's been changed in the last draft. And there is so many messes get created in that way from, for instance, accepting a red line sent by the other party. Never review the other party's red line. Take a clean version and run your own red line against your last draft and become truly expert at that software. And again, this is not the kind of thing that gets you a lot of attention at parties. But when you go to that negotiation with no question, absolute clarity about what has been proposed on the other side's last draft, you're in a wonderful position to understand what you're talking about.
Yeah, I think that's a very, very important piece of advice. I actually love it. I think that is really important.
I was afraid I'd bore you too much.
If our viewers would like to know more about you and what you're doing, where can they study a bit more about you?
Yeah, sure. So thank you for asking. So the business, the website for Tech Contracts Academy, which is our trainee business, is techcontracts.com, TECH contracts.com. And there we have, incidentally, in addition to information about bringing me on to train your lawyers or your contract managers or your IT staff, there's free resources. There are free contract forms, free contract clauses, all of which you can download, and articles. So that's techcontracts.com. And then my practice is Sycamore Legal, and that's where my staff and I do these kinds of deals. And I also serve as an expert witness. And that's sycamorelegal.com, SYCAMORE legal.com. And you can find all of our contact information there.
Right. And the book you published?
The book is called the Tech Contracts Handbook. It's published by the American Bar Association, and it's currently in the second edition, and you can buy it anywhere. It's actually a bestseller, I'm proud to say, and you can get it on Amazon or anywhere else.
Great, wonderful. David, thank you so much for taking out the time. I know you have a busy schedule. I've really enjoyed our talk and look forward to continue a relationship and work with you in the future. So thank you so much for participating.
My pleasure, Keld. Thank you.
Thank you.